It is the eternal question. It is the question on the mind of every client who comes into my office. It is the question on the mind of just about every person who might be searching for a divorce attorney. And that is, what is this process going to cost me? And unfortunately, the honest answer is an unsatisfying one. And the truthful answer is, it depends. It depends on a variety of factors. So in this video, I want to outline some of the factors that can cause your divorce costs to skyrocket, and I'm going to highlight some of the things that you can do to try to minimize your costs. But let me give you some ballpark figures so that you have at least some numbers that you can think about before you embark on this process. And I can only speak for myself in my own experience and my own practice. Many of my colleagues, my brethren, do not bill honestly and ethically, which can obviously result in your case costing significantly more than it should. So let's start at one end of the spectrum, and that is your agreed divorce. Some use the expression uncontested divorce. I think agreed is a better and more apt descriptor. And in an agreed divorce, that means that you and your spouse essentially agree on all the issues. You have an agreement on how you want to divide your assets. You agree on the custodial arrangement that is in your children's best interest. And you simply need to engage an attorney to paper your agreement and submit the appropriate paperwork to the court so that it's signed by a judge. And in a scenario like that, you can spend less than $5,000, maybe $2,500, depending on the lawyer you talk to. There are some lawyers who may offer a flat fee arrangement for an agreed divorce. Remember, an agreement means an agreement on all issues, no court appearances, no trial, no hearings, no mediations. You simply need someone to draft the paperwork. That is obviously the cheapest and most cost-effective way to get your divorce finalized. If you find yourself in that situation, God bless you. You are very fortunate, because most of my clients and most of the people that I know going through divorce have some very significant disagreements with their spouse, and that route is not available to them. The second route, this is what I would call a fast-track mediation approach. This is fairly common, and in this situation, there might be some disagreements, but the disagreements are not very intense. They're disagreements that we can probably work out and resolve at mediation. And in this scenario, you'll file for divorce, and you and your spouse and your respective attorneys will exchange some basic financial information. We call them sworn inventories. It's a spreadsheet that you each prepare listing your assets and your debts, and we generally provide supporting documentation for those assets. So for example, if you have a retirement account, then obviously you need to provide the statement reflecting the most recent balance. Usually we exchange 6 months to a year of statements so that the parties can see whether there have been any suspicious transfers or withdrawals, and if questions need to be asked and answered about that, then they can be. But that is essentially the fast track approach. Is we exchange this information, we do it freely, we do it voluntarily, we're very transparent about it. You exchange the inventories, and then we schedule a mediation and try to get the case resolved at mediation. You have to pay for the cost of the mediator. The mediator is usually an attorney who bills by the hour, and the cost of the mediator is generally split by the parties. Your attorney will be with you during the mediation, and of course you will be paying your attorney to represent you at the mediation. Most mediations resolve themselves in a day. Mediation is voluntary in the sense that the mediator cannot make decisions that are binding on you and your spouse the way a judge can. Mediator is there to facilitate a settlement. Most counties in Texas require you to mediate before trial. There's no rule on when during the process you have to mediate. Sometimes it happens very early on in the case when in a more amicable situation. Sometimes a mediation doesn't happen until later on in the case when we've done more exhaustive discovery or there's been hearings, etc. So it really depends on the dynamics of the case, but there is an expectation that you at least attempt to work out your differences before you go to trial. And the advantage of mediation is if you settle, you come out with what is called a mediated settlement agreement that is binding and irrevocable. You can't change your mind. You're bound by the agreement that you made. And that effectively ends your case. If you settle at mediation, the only remaining steps are to incorporate the terms of the settlement agreement into a final divorce decree, which then gets submitted to a judge for signature. And then the third bucket, I would say, is the more contentious case. And that's the case where you have some very significant disagreements over property and children, and you can't work it out at mediation, and you end up going to trial. So to backtrack, on the mediated, sort of the fast-track mediation approach, I would say in that situation, you probably get out of that less than 10 grand. Assuming there's not a lot of discovery you do before the mediation. You just do the voluntary document exchange. There's no court hearings. You go to the mediation, then you submit it to the judge. If you go the trial route, and if you go the route where you have multiple hearings, say a temporary orders hearing, most cases that are contentious involve discovery disputes where you have to file a motion to go in front of the judge and request that the judge order your spouse to produce items that you've asked for in discovery that they haven't produced. The range of cost on the contentious track is broad. I've had cases where people spend six figures. And in many instances, those cases also involve retaining expert witnesses who have their own fee arrangements, and they're also paid by the hour, and they have retainers, and you can imagine how much that can escalate the cost of your case. If you demand a jury trial and you want to have a case tried in front of a jury, then there are certain things you need to do pre-trial that add to the cost. You have to pick the jury. That adds time to the trial. Generally, a jury trial is going to result in a significantly more costly divorce. So we've got agreed divorces, we've got fast-track mediation, and then we've got the sort of no holds barred, we can't agree on what color the sky is, and we're going to go to trial. And that third bucket is the most expensive one. That's the one that generates the best cocktail stories, and that's the one where you're going to be draining your assets and subsidizing the college education of your lawyer's children rather than yours. Let's talk about some other factors that can drive up the cost of your case. One would be what you plead for, whether you plead for fault. In Texas, you can request that a divorce be granted on a fault-based ground. The two most common are adultery or cruel treatment. Cruel treatment could be physical or severe verbal or emotional abuse that you have experienced during the marriage. And those are claims that have to be proven. So if you're trying to prove that your spouse committed adultery, there are certain things that you're going to ask for in the discovery process. And discovery it's a cost driver. It's outside of going to final trial, discovery is probably the phase of the case that is the costliest. And discovery is essentially gathering evidence from the opposing party. You're asking for bank records. You're asking for, if you're trying to prove adultery, you're going to want to see text messages. You're going to want to see credit card statements to identify potentially suspicious transactions or dinners that your spouse may have had with their paramour. You may want to hire a private investigator. You may want to take the deposition of the paramour. You're certainly going to want to depose your spouse and ask him or her pointed questions about whether or not they've been carrying on an extramarital relationship. You're going to ask for social media messages, fake Facebook messages, Instagram messages, photographs. All of those sorts of requests can significantly increase the cost of your case. So if you're pleading fault, you have to prove fault, and that means gathering the evidence that you need to prove your claim, and that adds to the cost of the case. Discovery in general can be a big money eater in your case. Taking depositions, asking for requests for production. One way to mitigate or keep your costs limited is to be focused and strategic in your discovery. Only ask for things that you really need to prove your case. I can't tell you the number of times, and I'm not going to name any particular law firms, but there are some law firms where, regardless of the complexity of the case or how long the parties have been married, I'll get requests for production. These are requests for documents that you have to prove in your case. And they'll ask for like 90 requests for production. They'll ask for bartering records. Okay, it's 2026. That might have been a suitable request in 1826, but I don't think I've ever had a case where a client has actually had documents responsive to that request. Bartering records, right? They ask for it, the opposing attorneys, they just reflexively ask for the same thing. They'll ask for records going back 5 to 7 years. Now, obviously, if you haven't been married for 5 to 7 years, and you don't need to produce records going back that far, but if you're in a longer marriage, let's say 10 years, ask yourself, do I really need 7 years of bank statements? Is there something I'm going to find 7 years ago that's going to turn the case on its head? Probably not. But the problem that I see is there's a tendency by clients to mirror the litigation tactics of the other side. So if your spouse is going scorched earth, right? If their lawyer is being a bulldog and asking to produce all this information, then your inclination is going to want to be to do the same thing. But it's all coming out of the community pot. It's all community funds. It's all going to the lawyers. So I try to counsel clients, let's think about whether what we're asking for is actually going to be an exhibit that I'm going to use at trial. Is it actually something that's going to help prove the case? Ultimately, it's the client's call as to whether to ask for something in discovery or not. I try to give advice if I think the client is asking me to do something unethical or contrary to the best interest of the case, I can withdraw. But I would counsel clients, if you want to keep your costs down, be more limited in the scope of what you're asking for in discovery. Let's discuss the retainers. So what are the upfront costs? You meet with an attorney. Most attorneys, most family law attorneys, they bill by the hour. The two most common fee structures that you will see in a family law case are either a flat fee arrangement, which is very rare. I'd say I've only seen that if it's an agreed divorce or perhaps for drafting a premarital agreement. I charge a flat fee for doing premarital agreements. But for the most part, you're going to have to pay an initial retainer, and you're going to be billed by the hour against that retainer. I would say that in Austin, the range of retainers is probably between $5,000 and up to $25,000. And there may be outlier attorneys on either side of that spectrum who charge more or less. A retainer is typically not non-refundable. So for example, if you hire an attorney who bills at $500 an hour and asks you to pay a $10,000 retainer, well, that is 20 hours of that attorney's time. And if your case gets resolved in 10 hours, then you will be refunded the balance of the retainer. So you're essentially prepaying for your attorney's time, and any time that's not used is refunded to you. The amount that an attorney bills per hour also ranges. Some are in the 2 to 3s. I've seen attorneys that bill as much as $900 an hour. I would be wary of attorneys who bill too much seemingly and those that bill too little. A low rate can entice you to hire a particular attorney. And I've talked about this in another video, but often an attorney that bills a lower hourly rate simply pads their bill. They bill more hours than your case needs, and so it doesn't necessarily mean that ultimately you're going to end up spending less money in attorney's fees if you hire a less expensive attorney. On the other hand, I would say with respect to bigger law firms, bigger is not always better, and bigger law firms also mean bigger bills. So you may meet with an attorney at a large law firm. You might meet with the main partner, the face of the firm, if you will, and they will try to entice you or sell you rather on hiring them by telling you that, well, I might bill at $800 or $900 an hour, but in order to keep costs down, I'm going to have my associate, who has a much lower hourly rate, say $300, $350, it depends on the firm, do most of the day-to-day work on your case. And that is a nice sales pitch, but in my experience, it doesn't really result in cost savings to the client. If you engage a larger law firm, you need to know that those larger law firms have significant overhead, and that overhead has to be paid for, and that overhead is paid for by you. And by overhead, I'm talking about a nice brick and mortar office, I'm talking about receptionists, marketing consultants, associates, obviously the partners. So when you get your monthly invoice from that firm, you're going to see the initials of all the timekeepers that are billing time on your case. And you're going to see the associate initials, you're going to see a paralegal, and you're going to see some time spent by the partner, even though he told you that he's only going to parachute in for the trial or a significant hearing. And often the spreadsheet is going to reflect billable events where they're communicating with each other or they're reviewing your case file for the 5th time. You can imagine in a situation like that how the costs are going to escalate. And I would just caution you again against going with a larger law firm. You may think your case needs that and warrants that much attention, but trust me, the vast majority of divorces do not require that kind of manpower. And those larger law firms often operate on a volume basis. They have a lot of cases, and you may think that you're going to have personalized attention, or your case is going to receive more attention because there's more staff. But the reality, again, is you're often treated like just another number, another case, and an associate may leave, and then your case gets pawned off to someone else, and you're not getting the personalized attention that you thought you were going to get, but you are getting those massive invoices. And at the end of the day, the outcome of your case will have been the same if you'd hired a solo practitioner or someone with a good lawyer with good credentials who doesn't have a massive staff that they have to support and feed. Let's talk about some other factors that can increase the cost of your case. We've talked about the discovery process. We've talked about whether you plead for fault like adultery or cruel treatment. Another cost driver is experts. If you have a complex property case and you want to hire a forensic accountant to perhaps value a business, maybe you have a medical practice or a law practice, or I had a case where I represented an optometrist, whatever the business may be, if it was established during the marriage, it's considered a community asset, even if you're the one who's running it and managing it, and even if it's ultimately going to be awarded to you by the judge. It's still a community asset, and you may want to hire a forensic accountant to determine what it's worth. Your spouse may want to hire a forensic accountant to determine what your business is worth. You may both end up hiring forensic accountants because you may not agree with what the other accountant thinks the value of the business is. So that is a significant cost driver. If you're both hiring experts, and these experts also charge retainers, they bill by the hour, and that can add tens of thousands of dollars to the cost of your case. And if you don't settle your case and you go to trial, you've got to pay those experts to testify at trial. And at least with respect to whatever the issue is that they're testifying about, it becomes a battle of the experts, right? You've got two competing valuations, and the judge has to pick the one that is the most reliable and accurate reflection of the true market value of the asset. You may disagree about what your house is worth and have to hire an appraiser. And again, that's a scenario where you could potentially have two competing appraisals for what the house is worth. In many cases, the family home is the most expensive, the most valuable asset in the estate. Now, what can you do to contain that cost? Well, you can agree that you all are going to have a joint expert. You're going to select someone, you're going to mutually agree on someone, and you're going to accept whatever value that person comes up with. When it comes to real estate, you all can agree that you're going to go by the Zillow value, or you're going to go by the value that the county says it's worth, or you can simply agree that you're going to sell the house and split the proceeds. And in that scenario, if you're going to sell the asset, then you don't need to hire an expert to tell you what it's worth. It'll be worth whatever somebody's willing to pay for it. Harder to do that with a medical practice or a business, but certainly with real estate, that is one approach that you can take. And in the custody context, you can have experts there too. You can petition the court to do a child custody evaluation and appoint a private forensic psychiatrist or psychologist to do a custody evaluation. Significant cost driver if you elect to do that. The expert in that situation may want to do psychological evaluations of both spouses. They will, depending on how old your child is, they'll interview the child. They'll talk to collateral witnesses like family members or teachers, nannies, babysitters, other people that have had contact with the child and are familiar with the family dynamics. Those investigations can be very lengthy. It adds significant time to your case when you do a child custody evaluation, or you hire a forensic accountant for that matter. You don't have to do a custody evaluation. Most people shy away from doing that because invariably, if you have a child custody evaluator, one parent is going to disagree with the recommendations that are made by the evaluator, or think the evaluator is biased or bought and paid for by the other side, whatever it may be. So, ultimately, that is a determination that's made by the judge. I can't stop the opposing party from petitioning the court to appoint a child custody evaluator. Obviously, there have to be enough resources in the community estate to pay that person. So these are sort of luxury items that not every family has access to, even if it's something they want to do, because the money is simply not there to do it. So experts, discovery, pleading fault, those are all things that can increase the cost of your case. What can you do to mitigate expenses? Well, I've talked about settlement and mediation, the extent to which you all can work things out and reach agreements. It's really up to you and your spouse. People wrongly assume that lawyers are stoking conflict in cases and stirring the pot, so to speak, and pushing their clients to wage petty battles. I can't speak for other attorneys, but I know in my practice, I'm often encouraging my clients to put the brakes and to pick their battles and to be more selective about what they're fighting for in order to keep costs down. Because believe it or not, I'm not interested in going, even if I'm getting paid, I don't want to go down to the courthouse and argue about silly, petty things like airline miles. I want to go down to the courthouse and argue about things that are significant and important and are going to have far-reaching consequences, especially for the children who are at stake in the process. So I try to focus my client on what's really important, both because focusing on other things is often not productive. It's not going to move the needle on the ultimate outcome, and it's going to cost the client more money. But divorces are emotional, they're contentious, and people don't always behave rationally, and sometimes I'm overruled. But if you want to keep your costs down, listen to your lawyer, pick your battles, try to reach agreements with your spouse where you can. I know it's difficult, but if you treat your divorce like a business decision, and you can make better decisions about how the case is going to unfold. So I think we've covered the main issues. We've talked about the retainer. We've talked about hourly rates. We've talked about pleading fault. We've talked about the discovery process. We've talked about mitigating expenses by reaching agreements and going to mediation. And of course, to the extent you can avoid going to a final trial, then of course that is going to significantly constrain the cost of your case. Mediation is not the only context in which you can settle a case. You can also settle your case through informal discussions, we'll call it an informal settlement agreement. That's an agreement that is prepared by the attorneys. You don't need to go to mediation to do that. It can also be submitted and filed with the court and approved by the judge. So that's you can always settle the case before you end up going to trial. And in fact, that is what happens with most divorces. A very small percentage of divorces go to trial. Even in my practice, I consider myself to have a fairly significant trial practice. But most of my cases are also resolved at the negotiation table before we get to trial. I hope you found this video helpful. If you want to reach out to me and schedule a consultation, feel free to go to my website. Thank you.